This is WPSL Port St. Lucie.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, Attorney Stuart M. Address.
Good morning, Treasure Coast and beyond.
Hey, we're on the net. You never know.
I guess that doesn't really work without the right sound effects.
I'll work on that.
I'm Stuart Address, and this is another edition of Ask a Lawyer. You know, we've been doing this for almost a year.
Time flies, doesn't it?
I mean, not too much longer until it's a year.
Mm-hmm. Well, I told you when you came in, it's the fastest hour. I tell everybody that, and it is. It really is the fastest hour. So it makes for a very fast year, too.
Now, do they bring me a cake at a year, or do I have to bring in a cake?
I think, you know what, if you want cake.
Maybe all my listeners who send me cake, I'll get one cake, right? All right, folks. Well, I hope you've all had a nice week. I do have a preliminary announcement. It is an official announcement that was handed to me. All individuals arriving in the state of Florida within the past 96 hours from states north of North Carolina must report to the Fort Pierce Immigration and Deportation Center by noon tomorrow for return, because it is they who brought the cold. I don't want it.
But you know what's funny? They come here and they think it's warm. It's warmer from where they come from.
It's warm for them. It is. It's warm for them. I was tempted over the last couple of nights. I was tempted once or twice to maybe put the heat on, but nah.
Yeah.
All I did was turn the fan down. You know, I've been here 25 years now. And I do like the cold. I've actually enjoyed the past couple days.
So do you see the seasons? Because I've been here for a little longer than 25 years.
No, I don't see seasons.
Sure you
here.
do.
No.
You just said it was too cold.
I see 2 weeks. 2 weeks if I'm lucky, 1 week maybe.
But we have degrees of hotness.
Yeah.
So
but
when it's not as hot, that's winter.
No. If it's hot and if you can walk outside and have a blanket thrown over your face immediately, as if you're being kidnapped in Colombia or some such place, it's hot. I mean, everybody tells me about dry heat. I don't know. I have a couple of people listening. Tucson is listening. Tucson, Arizona. I don't know about dry heat.
No, there's dry heat for you.
But I don't know if I'd like it better or not better, but it sounds to me as if you're not throwing something that you could really feel on top of you, weighing you down, maybe it would be better.
Here's the difference. Here, if you wanted to hang your laundry out in the yard to dry, you cannot. In Tucson, you put it out, you might as well just 5 minutes later go get it.
Sharon,
it's
is
dry.
that correct? Can you hang your laundry out there in Tucson and let it dry just like that? I know my grandmother used to do that in Montreal in the old days. I think you're right. We can't do it here.
Not really. It doesn't dry well.
Tucson is saying like an oven.
Yep.
So, that is the way it goes.
No, I don't know which is better. I guess that's a personal preference if you like a little bit more of the humidity versus that dry heat.
For me, if you're going to give me this cold, give me some snow, please.
Okay.
Give me some snow. I haven't seen snow in 25 years.
I'm from Chicago. I don't miss it.
I miss it. I do. I don't necessarily miss the cold, but I miss the snow.
Plan a vacation at a nice ski resort and just sit in the lounge and sip
Well, I don't
warm
ski.
rum.
If I go to a ski
no,
resort, I'm going to break a leg.
I don't ski either. I would just sit in the lounge,
I've always thought of planning a nice winter vacation somewhere, but I figured there's no guarantee it'll snow.
Well, you have to wait till it's already snowed. Right. And then hurry up and throw a vacation together.
Good advanced planning.
But make sure travel is back up to 100%, because you don't want to get stuck in the airport anywhere. That's horrible.
All right, so what are we going to talk about today? What are we going to get people to call us at 340-1590? You can call us about anything, really. Throw me for a loop. I enjoy it. If I can answer your question, I will. If I can't, I will tell you. Try to help you where you might be able to get the answer. But, as we've talked about for a long time here, I do most parts of civil litigation. Lots of things walk in my office. Some very weird things walk in my office.
You mean cases, not
Yes.
like people.
No. Okay. Being honest here, you got me on a polygraph. Some weird people have walked in my office, too. I mean, I've had 2 Wiccan walk into my office.
Really? Yeah.
One put a curse on me.
Okay.
That
How'd
was
that
not
work?
a- that was-
How'd that work out for them?
That was not a fun experience. Because, I don't believe in it, but who the heck knows? Only once in a little over 12 years since I've had my own solo practice did I have to lock the front door
Oh, no.
because I thought somebody might show up with a gun.
Wow.
Yeah, that was a little bit scary. We've had a couple people come in that were mentally unhinged, just wandering around. And only once in my entire 33-year career have I had to break technically what is considered attorney-client privilege. When somebody calls our office, even if they don't hire us, the communication is privileged.
Okay.
I can't,
Well, because they're a potential client.
right, they're telling you private information that would not otherwise be disclosed, and for that limited purpose, that they have attorney-client privilege.
Okay.
And I can't go, telling it to somebody else. And I can't go then representing the other side if they call me 10 minutes later.
Okay.
I had that happen once.
Okay.
But once we got a call, hopefully, a year ago or so. Well, my paralegal got a call. I didn't really take it. That scared her. And she called me and asked for my advice. And it was a woman who was basically, according to that woman, ready to hurt herself if she didn't get some miraculous, immediate legal assistance that could certainly not appear within seconds. And, I asked my paralegal exactly what did she say, how did she sound, and did she say anything about how she might hurt herself? Because I at least know that when people don't know, they're usually just spouting, energy. But if people have a plan, you need to worry a little bit more.
Usually the threat of I'm going to kill myself, you don't do that with like the attorney's office. You might say that to a spouse, you might say that to your mother, because you're trying to win the argument by scaring them.
Well, when I heard what I heard, I told my paralegal, first of all, call 911 and tell them what's going on, and send them over to her house.
Right, because you could be saving her life.
Yeah. And then I said, now as an attorney, you got to remember, you got to try to protect yourself too. I said, do a memo to the file.
Yeah.
Everything she said, as word for word as you can remember it, what you said, the call you made to me, the questions I asked you, what you told me. Let's get it all down there in case one day we get a bar grievance because she claims that we breached attorney-client privilege, which we never did.
Did you also put a letter together telling her that you're declining her case?
No, we just do that by phone.
Okay.
But that was actually scary.
Sure.
Wondering whether this person was really going to hurt herself.
And then that information's dropped in your lap. What are you going to do with it?
Right.
That's the thing.
Doesn't happen as much in general civil litigation. It happens more, from what I understand, in family court. Where things get pretty testy.
Yeah.
I can tell from experience sometimes things get pretty testy.
Well, there's passion involved.
Well, there's passion involved in civil litigation, too. If you have a good sexual harassment case, there's passion involved.
Okay.
Maybe there shouldn't have been passion involved.
Yeah.
But there's passion involved. A lot of the cases I handle, discrimination, civil rights, family medical leave, there's passion involved, let me tell you. Some of the times when I hear, some of the things that have been done to people, I get pretty irritated. I guess that's why I do that kind of law. If I didn't, maybe I wouldn't. I would hope that, attorneys who practice in whatever area law they practice, get irritated when they hear some of the things they hear, because if they don't, I think they should be in another area of the law, or that client should probably stay away from them.
What's amazing is this kind of thing has probably been going on since the beginning, since the very first employer-employee or, man-woman in the workplace kind of thing, and yet nothing really changes. I mean, we learned along the way.
That's not true. That is not true. I believe a ton has changed.
You think okay, but it still takes place.
It takes place. But I do believe an extraordinary degree has changed. I still get crazy fact patterns when people call my office. And let me tell you something, I make money off of them. But I don't hear it, and it doesn't seem to be as pervasive as it used to be.
Well, that's a good
thing. Now,
thing.
it sounds like it in the last year. And it's a good thing. But with the Me Too movement, it certainly sounds like it's exploding everywhere. It's happening everywhere. It happens every single day because women are coming forward and talking about it.
Yeah, but that's just the media. I mean, you're hearing about everything.
Right. So you're hearing about it more, so it seems like it's more prevalent. But I really don't think it is more prevalent. I think it's much less prevalent, but it's now more socially acceptable to acknowledge it, to come out and discuss it.
Okay.
And so that's why we're hearing about it.
All right. So it went on, but maybe unreported.
Oh, I think so.
Years
think,
past.
I think in 60s, 70s, I think it was absolutely daily fact of life for most women, if they were in the workplace, to have their butts pinched, to have comments made about how they dressed, how they looked. I think that was probably, and call. If you were working in the 60s or 70s, especially for a woman, call. Tell me whether I'm right or I'm wrong. I mean, it's not an unimportant issue. But I think it was an almost everyday occurrence where women had to be subjected to that type of harassment. And interestingly, men too, a much lesser degree, but what wasn't accepted until probably about 15 years ago, I know because I had a case, is that men could be sexually harassed. And the whole reason that was never accepted conceptually was the attitude, they're just going to enjoy it. So how could you sexually harass them? But that was where the whole societal and legal misconception came from. Sexual harassment is not about enjoying it or not enjoying it. It's about power. And whoever is in the power situation can inflict that upon a subordinate. And if you have a woman who is CEO or a supervisor or a manager, and you have to report to her and you're dependent upon her for reviews and raises and what have you, she is in a position to inflict sexual harassment. And then you as the guy have to make a decision. Gee, do I complain about this? How am I going to look if I complain about this? What are people going to think about me if I complain about this? How's it going to affect my career? Wow, that sounds really similar to what a lot of the women say that goes through their minds when they have to decide, are they going to speak up? But they speak up now after decades of not. Men are just beginning to speak up, recognizing that the issue is power, not gender. But I still think in society, if you have two news stories on back to back, a woman claiming sexual harassment against her male boss, and a male claiming sexual harassment against his female boss, I think one story is going to be taken much more seriously than the other.
Sure.
And that's just where society is. And society, it changes over time, often very, very slowly. I see a comment here on Facebook Live. The same is true for domestic violence. Domestic violence used to be a secret. You kept it as quiet as possible unless you got to the point where, life was at stake. And I do believe we have a good friend from Facebook Live from Tucson on the line. Sharon, hello.
Hello.
How are you?
I'm fine.
Well, what do you want to say?
Hey, so what I want to do is I'm fine. I want to, okay, I'm watching you live and talking, so I'm going to go in the bathroom.
Well, I don't
Yes,
need
oh.
too much information,
No,
Sharon.
there's a delay.
Yeah.
I'm sure that there's a delay.
No,
There
I
is
know.
a
I
delay.
know what
Well-
I know what she means, but I wanted
No.
I wanted to forestall any further bathroom discussion.
So you have to
No,
probably.
it's the quietest
the
place
phone.
in the room.
Okay.
What can I say? So, yes, I did that on Facebook Live, but I have to tell you that in the 80s, when I went to go to get my divorce, I was told by my male lawyer not to bring up the domestic violence because the judge does not want to hear about dirty laundry.
Was it a no-fault state?
Oh, no, there were children involved,
So-
and he was pretty spiteful.
But I mean, the divorce, was it no fault, or did you have to prove cause?
You know, it was in the 80s. That was a long time ago.
I would
don't
suspect
really
it was a
remember.
cause.
That could have been.
So I would think that, domestic violence would have been really relevant in those situations.
Yeah, well, I was told to keep my mouth shut.
Well, it doesn't surprise me. It
Yeah.
would be consistent with, I guess women generally being told, not to speak up. The 80s were really, at least I know from my mother's experience, maybe late 70s, when women really started going into the workplace, unless they were in the workplace, pursuing a career. But that's sort of when American society switched from a one-income earner family to two-income earner families, just to make things, make the ends meet.
Correct.
And so when you have the influx of women then in the workplace, it's sort of like, well, you play by our rules, and if you don't like it, go home.
Mm-hmm.
And maybe the law was even like that back then, because certainly we didn't have, Title VII of the Civil Rights Act at that point, in terms of really, we may have had it, but not the way we have it now.
Right.
Well, Sharon, it doesn't surprise me. I think people now are much more willing to speak up about, sexual harassment, domestic violence. That's good. There are certainly situations where I think, people are in danger even speaking up, and, now there are shelters that, keep their location anonymous. But it's a dicey situation now. Obviously, domestic violence, it becomes a criminal issue and a family court issue. Sexual harassment, other types of discrimination, that's where I get involved as a civil litigator. So we're sort of in, two different courts. Well, thank you for calling.
Yeah. Yeah.
And,
It just made me think about what happened to me, and I wished it would have been different.
I think a lot of people probably look back in retrospect, and I think for one area or another, to a lesser or greater extent, we all look back and think some of the things should be different, and some of the things that are most painful probably should have been handled differently eons ago.
True. Well, thank you. I appreciate
You're
you
welcome.
taking my
Thank you for
call.
calling, and I hope your heat out there is not a moist heat.
It is. We had a huge rainstorm last night.
Wow.
It's cold. It's humid. Oy vey.
You have humid? Oh my goodness.
Yes.
It's the change of the
Probably
season.
we're up into the double digits. I don't know.
Double digits of humidity, you mean?
Yes.
Yeah, not like us where we get to triple digits very quickly, right?
We're always up in the high
Yeah.
double digits.
Yeah.
All right, Sharon, thanks very much.
Thank
Speak to you
you.
soon. Bye-bye.
Bye.
Yeah, that's true. You have a host of not just women's issues, because they're male issues too, to a lesser extent. But these types of issues that were behind closed doors, police didn't take them seriously. Why complain if the police are going to show up at your door and just leave you there, and not do anything about it? I think we live in a different time. We may have actually gone over the edge in the wrong way. I'll be honest with you.
I think so too.
Okay.
Thank you, OJ.
Well, I don't know, OJ, but these days, if the police show up at your door, one of you is getting arrested.
Some,
Then
or
they'll
maybe,
sort of
maybe everybody's
They'll
going.
sort it out the next day or after the weekend.
No, someone's
but
going.
one of you is going to jail. And I don't know that is. I understand why they do that, because God forbid they leave and somebody kills somebody. But I think we've gone over the edge in the wrong direction in that regard. And hopefully at some point the pendulum swings to a more neutral, where you take things seriously, you investigate them, but it's not a knee-jerk reaction where you do the same thing every time, regardless of what you're hearing.
But you can also look at the other side of the coin with the police departments too. If you watch like these shows like Live PD or Cops or something, it's like they're babysitters for adult people who may have had just a little too much to drink that night and they can't get along with each other. And then the cops come out and they have to, and they're playing with the same people over and over and over.
That's true.
So maybe how do you write the rules for these things?
Do they still have drunk tanks? I don't know.
Yeah.
Take them in, let them sleep it off, and release them. Catch and release. Not just an immigration policy.
Yes.
A policy if you're drunk. Anyway, so what were we going to talk about today? We were actually going to talk about something different. And as usually when I start my little intros, we go through half the show. But so we'll start this, and I'm sure we'll probably speak about this over the next few weeks, although I do have an idea. I don't know who's listening, probably not. I do have an idea for next week that I'm actually trying to speak to somebody about to get a little bit more knowledge. In addition to the research I did, I won't even discuss the topic in case it gets put off a little bit. But we'll see whether this new topic now gets interrupted itself.
Well, but that's a huge tease,
Or
Stuart.
a more socially,
We call that a
socially significant topic
tease.
that involves people being run off the road. Let's just put it that way.
Okay.
All right. We're going to talk today a little bit about disability accommodations. So not necessarily discrimination, although it's part of it, but accommodations, which we are getting more and more calls about. And disability accommodations typically occurs under 3 separate federal statutes. Depending upon what the situation is, 1 or more statutes may be implicated. And that is Family and Medical Leave Act, Workers' Compensation Act, and the Americans with Disabilities Act. And, just as a sort of an overview, obviously with the Workers' Compensation Act, what you're talking about is somebody's been hurt on the job. They're still able to work, but the doctor says not to lift more than 10 pounds, not to sit at a desk more than 30 minutes at a time. Whatever restrictions are then written down by a doctor. And the employee comes back to work with this note, and the employer says, well, I can't do that. So go home, without pay, or you're fired.
What happens if they get fired before they even return from that injury?
Well, then we're looking at workers' comp retaliation. Now, workers' comp, I refer to a couple lawyers, other lawyers. I don't do that.
Okay.
Workers' comp retaliation, I do, because it's like any other retaliation statute. Then you're probably looking at retaliation. But, if you're going to your employer with a note, the question is, how do they react to the note? Now, Family and Medical Leave Act, okay? Not looking at you need family medical leave because a family member, is ill or something. Let's talk about yourself. And something happens and your doctor says you need some time off, either X number of weeks, which implicates, the Family Medical Leave Act, or you need intermittent time off. Let's say it's, due to a difficult pregnancy. And yes, you can go to work, but we want you to get up every 15 minutes and walk around. So you get this note that says, patient must get up at least, 4 times an hour to walk around for at least 5 minutes a time. So now what does the employer do with this? And then it also comes into play under the Americans with Disabilities Act. And let me tell you, the definition of disabilities is very broad. It's not what you might initially think. And some things can be disabilities in certain circumstances and not in others. For example, diabetes. Is everybody that has diabetes, are they disabled under the ADA? No, they're not.
Okay.
But they can be, depending upon what the needs are.
Or they can become more ill than.
All right. So what usually happens is either you're bringing back a note from a doctor that says, here are some limitations for a certain period of time. Or you have your own problem. You have a back that acts up, 2 or 3 times a year, really bad, and you know it's going to happen 2 or 3 times a year. You have degenerative disc disease, and you need some accommodation. So you tell your boss, last night my back really went out. I need to be able to do X, Y, or Z for the next couple weeks. So now you have 3 different situations. You've gone, you have a couple notes, some situations. What happens? Well, the FMLA obviously is only impacted if there are 50 employees in the company within 75 miles of where you work.
Okay.
And if you've worked there for at least a year and you've worked at least 1,250 hours in that year. So there are some prerequisites there. Workers' comp, the only prerequisite is that the company is big enough to be under the workers' comp statute.
Then you must have been hurt on the job.
Well, yes. Otherwise, it's not workers'
Right.
comp. And for the ADA, which falls under Title VII, it's 15 employees. Under that, people are in a no-man land.
Mm-hmm.
So when you're dealing then with the ADA, and you're dealing with the FMLA, and you're dealing with workers' comp injuries, and they come to you, and they ask for an accommodation, the employee has now performed his or her obligation. They have made a request, verbally or in writing. Doesn't matter except to somebody like me. Okay, because if they're calling me, I'm asking them, did you put it in writing? And why am I asking that? It's so much easier to prove. And I want it in writing. But it doesn't have to be in writing. So you've made your request. Now, what is the employer's obligation? The employer's obligation is to engage in what is called an interactive process. That's the language under the Americans with Disabilities Act. And the interactive process isn't complicated, but it does require serious attention. The employer can look at the requested accommodation and can say, well, gee, that's reasonable. Well, I guess there's not a problem there. The employer can look at the requested accommodation and say, well, I can't let you get up every 15 minutes. I can let you get up every 20. Would that work? Now, it's back to you. So you say, yeah, that'll work, in which case, wonderful. You've solved the interactive process issue. Or you say, no, that won't work, and it better be real, and your doctor better support that. If not, then you go back into the interactive process again. You say, well, no, that won't work. I need this. So does the employer have to give you the accommodation you requested, even if what you've requested is reasonable? No. The employer has to give you a reasonable accommodation, not the reasonable accommodation. So you request one type of an accommodation. Let me come in late, and I'll work to normal ending time. And the employer says, well, I can't let you come in late, but I can let you leave early. That is unless there's a factual reason why it's not. Mm-hmm. That seems to me, an alternative reasonable accommodation. If you can't work 8 hours a day, you can only work 7 hours a day. That seems like a reasonable accommodation. The employer has not given you what you've asked for, but has given you essentially
Well, that's
the
a
equivalent.
compromise. Yeah, it's a compromise. Here's
Okay.
what we can work with.
But it's not just a compromise. It's a compromise that solves the problem that's been presented and medically solves the problem that's been presented. So the interactive process goal is to try to reach a point where an accommodation is given that is reasonable, even if it's not what you've asked for. Now, what if the employer says, and this is when I start getting calls, well, I can't do that. There's just no way I can do that. I don't have another position for you. I don't have anybody that could cover for you. Well, the employer does not have to give an accommodation if it's not reasonable. And what is reasonable changes under the circumstances. Every job is different. Every employer type is different. If it cannot be done reasonably, it does not have to be done. And it's not a violation of the ADA or the FMLA or workers' comp law. Okay? You get into other considerations there. They could send you home on leave. And there are requirements as to whether they must make you use your paid time off that you may have first and then go to unpaid leave, or do they start with unpaid leave? Or if it's a company that has short-term and long-term disability programs, what do you have to do? But sometimes sending you home is not a violation of the law, even if you're being sent home unpaid. Because if you've asked for something that just is not going to work, the employer doesn't have to do it. There are lots of tests and factors that go into what is reasonable, and we can talk about that maybe a little bit later, but it has to be a reasonable accommodation. So there are three main categories of reasonable accommodations. The first is modifications or adjustments to an application process which enables an applicant with a disability to be considered for the position. So here's a prospective employee, and it applies there as well. In case I didn't make that clear, because I probably didn't, as I'm talking about employees. So here's a prospective employee. They have rights under the ADA as well. They don't have rights under the FMLA. They haven't qualified. They don't have rights certainly under workers' compensation. They're not an employee. But they do have rights under the ADA. The second is modifications or adjustments to the work environment or to the manner or circumstances under which the position is performed that enables a person with a disability to perform the essential functions of that position. Now, red bells should be going off. Fireworks should be going. Essential functions of the position. That's legalese. That's the way lawyers speak. Reasonable accommodation. That's lawyers speak. All these things have to be defined, and they are defined, either in statutes or in case law. And what you might think it means may not be what it means. That's what we often have to explain to people. So essential functions of the job. If your job requires you to be on the phone, you're in one of these bullpens, you're one of these horrible telemarketers. You're driving me crazy. Oh, my goodness. But that's your job. Or let's be nicer to you. You work for QVC or a place like that. And
You're taking orders.
You must be on the phone. That's your job. For you to then come in with a request for an accommodation that takes you away from the ability to be on the phone for half the time, half hour out of an hour, I guarantee you it's not going to be a reasonable accommodation. Now, might there be a reasonable accommodation in saying, look, I can't keep you as a customer service rep right now on the phones. There's just no way I can do that and give you what you want. But I can switch you to the back end where you're processing, paperwork. And there you can get up as you need to get up. That's a reasonable accommodation. Changing your job can be a reasonable accommodation temporarily if it works for you and for the employer. Okay, it allows something that could not otherwise be done because you can't perform the essential functions of your job with the requested accommodation, so you get a different job, which is different than the FMLA, where when you are certified to be able to return to work, you must be returned to your job or a substantially equivalent job, not some other job. So it's a whole bunch of different issues here. Number 3 is modifications or adjustments that enable an employee with a disability to enjoy the equal benefits of employment as to other people who are not disabled. So this might be a change in your environment. It could be a change in the chair you use, that accommodates whatever your situation is. It could be moving you to a different location for whatever reason, so you're closer to the restroom. There could be a whole bunch of, could be giving you a desk that's higher or lower. It could be allowing you to have access to a wheelchair, even though they're not generally, in this narrow little confines.
Right.
Could be a whole bunch of things, but it's a modification to the workspace. So you come up with all these different possibilities, and the law cannot address each one in a statute or an administrative regulation. So what you get to is the gray area of the law, which is where the law lives. There are some things that are black and white, and usually they don't get into litigation because they're black and white. The law that people argue over is the 90% that is gray, where there are standards and tests, but no clear answer. You have to apply the facts and the law to the situation. And how I apply it as a lawyer might be different as how the lawyer across the street applies it.
Or even how the judge interprets it.
And then we have to see how does the judge apply it. And how the judge applies it may be different than how the appellate judge applies it. And how the appellate judge applies it may be different than the Supreme Court. This is law. Imperfect as it is.
That's
Okay?
what we got.
So you can also have accommodations, let's say, turning a full-time position to part-time, temporarily. The point is, though, that when the disability, if it's a temporary disability, when the disability ceases, your regular position or a substantially equivalent one needs to be available to you. If it is a more permanent type of disability, you're going to have back problems, the rest of your life, or these flare-ups are going to continue, every other month, and we can't exactly tell when, but they're happening. Then the type of accommodation is going to be very different. Sending you home is not really an answer because the employer has to send you home every other week. Even I, who represent mostly employees, would say that is too much of a burden on the employer.
I was just thinking you're going to lose your job.
Well, it's not, but that's the issue, is it rightfully or wrongfully? I would say even then an employer has a right to be able to conduct
But then that becomes a permanent disability, and that's a whole nother process, because how can you work if you have a permanent disability?
No, what you're defining as a permanent disability for Social Security purposes is not a permanent disability under the ADA.
Okay.
And while the employer who operates this factory over here across the street cannot make a reasonable accommodation for you, let's say, legitimately cannot make a reasonable accommodation for you, the candy store across the street might be able to give you a job that accommodates you.
So you should find something that suits you better.
Oh, you have a duty, obviously, to mitigate your damages. It's assuming even you have a legal case, you have a duty to mitigate your damages. If, you can't work at a factory, but you can work in an office, and you go apply for Social Security disability. Now, I'm not a Social Security disability lawyer, but I'm pretty sure you're going to be denied. You're capable of working, just not in that environment anymore.
Right.
So the real question becomes, what happens if the employer fails to engage in the interactive process. It's clearly required. What if the employer fails to engage in the interactive process? Gets the note from your doctor, cannot lift more than 10 pounds for a week, and says, you're fired. Or says, go home without pay.
Or do it or you're out.
Right. Doesn't have this discussion of how can we accommodate you. Can we accommodate you? But just takes precipitous action. Most likely there's an ADA violation, which gives you substantial legal remedies. Okay. What if the employer isn't as egregious as that, but fails to engage in the interactive process, and so you're left in a position, because you weren't fired, you're left in a position where the doctor has told you not to do something, and it's either you have to do it or you have to quit because you haven't been fired. Well, it's also a good time to call a lawyer, because a lawyer might be able to get you that reasonable accommodation or get that interactive process going, or get the EEOC involved in a mediation, or do something to help you, or at least counsel you on the best way to quit your job so that it can be effectively argued that it was a constructive termination, not a resignation. Nothing worse for a lawyer than to have a client call, I've already quit. Oh my God, why did you do that?
Yeah, that's kind of a resolution, isn't it?
Yeah,
You've resolved the problem.
I might have helped you solve the problem. I might have helped you quit in a way that looks like a termination. You know, call us early. Don't call us late. So when the employer fails to engage in the interactive process, we get into a problem. Now, among the considerations for an employer when they are engaging in terms of what is reasonable, again, includes things that depend and change upon the nature of the employer. It could be dependent upon the cost of the accommodation. If you need a piece of equipment that will help you do your job, but that piece of equipment is going to cost $10,000, is it reasonable? Maybe it is. Maybe it's not reasonable to ask the employer to spend $10,000.
I'm sitting here going, not going to happen.
Okay, well, you know, there are industries where that just would not be an extraordinary expense. Most
For
smaller,
one person.
Yeah, well, okay,
You must be
Well,
really valuable to the company.
maybe, hopefully.
Yeah.
You know, but I can understand where that typically is not going to be reasonable. The overall financial resources of the company, in terms of what you're requesting, is what you're requesting going to force the employer to hire part-time help while paying you? Is it going to force the employer to have two people perform the same job? You look at the overall request of what's being asked for, what is reasonable, and then what are the financial consequences? How does it affect or impact the operations of the employer? And we sort of touched upon that. If you're a 911 operator and you've got to leave your station every 10 minutes to go to the bathroom, and I'm not making fun of that.
No, but that is a problem.
Okay, then I don't think you can be a 911 operator.
Right.
You're unable to perform the essential functions of the job. You know, if you're on the phone and somebody's called and you need to stay on the phone while help arrives, you can't run to the restroom. You may not be able to perform your job. Now, is that a temporary condition? Can they then move you to a different area? Well, those are all very good questions that lawyers get asked all the time. And it depends upon the facts.
What if simply you were hired for that job? You're
matter.
trained for that job.
Doesn't matter.
Okay.
Once you're an employee, you have rights. And if for whatever reason you can no longer perform that job temporarily, we look at it in terms of how can a reasonable accommodation be made, if one can.
Now, earlier you mentioned like your back goes out several times a year. Once your employer knows that you may have this problem coming up again, after you get through your crisis period and you're better and you're let go because they know this is going to happen again, do you have a case?
There's this wonderful song. I don't want to sing it because I can't sing the song. Call me. Call me. Yo, you have a case.
Okay.
Now, as with everything else in the law, can things be done in a very subtle way that's hard to prove? Sure. Are there ways that lawyers can often prove them nevertheless? Yes. Are there some situations in which the employer is going to get away with it? You betcha. Okay? But if you are let go, or if any adverse employment action is taken as a result of a disability that is likely to reoccur, and you can prove that, remember, proof is by a preponderance of the evidence, 50% and a feather, then yeah, you have a case. There are some inferences in the law. Usually, if adverse employment action is taken within 30 days of an event, which would be considered protected activity, there is an inference that it is causally related.
Okay.
But the longer the period of time that goes, the more tenuous any argument is that there's causation. We've had people call us and say, well, in 2012, he pinched my butt and made comments about my breasts, and now I'm fired. I want to sue for sexual harassment. Well, first of all, the statute of limitations has passed. But even if it hadn't, and the issue is only causation, I'm sorry. If that happened in 2012 and you're now trying to complain about it because you got fired, chances are you were fired for a different reason, and it's not causally related. Now, if it happened 90 days later, so you don't have the 30 days where you're going to get an inference, might a lawyer, depending upon the facts and the circumstances, become suspicious? Sure. Well, I've seen cases where employers try to wait a reasonable period of time and then go do their dastardly deed. Absolutely. And sometimes they're sloppy. And when you can prove that, you have a good case to win. And as I've often noted in our civil justice system, more likely you have a good case to settle, because very few cases really go to trial. But here, we're sort of looking at the goal. The goal is for the employee to make a request. Got to make a request. Verbally and you got to make a request. You sit with that doctor's note in your back pocket and say, well, the employer knew because he could see how much pain I was in. I'm sorry. No. I was afraid to ask for the accommodation. I'm sorry. No. The employee's got to request the accommodation. That's where it starts. The employer then has a duty to review whatever information is provided, engage in this interactive process. This interactive process doesn't have to take 8 weeks. The interactive process could take 30 seconds in certain situations and still be legitimate. Again, depends upon the facts and circumstances. But the employer duty is to engage in the interactive process and try to reach a reasonable accommodation, if possible, if you really are entitled to it. And if that happens, that's consistent with the law. And if you don't like the accommodation that was reached, but it's still reasonable, then no, you don't have a case. At least not when you're going to win. Okay? Doesn't have to be exactly what you want. The cases that typically get filed, or where charges of discrimination are filed with the Equal Employment Opportunity Commission or the Florida Commission on Human Relations, are those situations that, hopefully if an attorney is involved in the filing of them, are more clear-cut in terms of there being a potentially viable case. Not one where you filed it on your own, after they offered you something that was eminently reasonable, and you just didn't like it because you weren't getting your green M&Ms. I don't know what to tell you about that. So it is, we're running out of time, and we'll do a lot more later, but it is a serious, serious issue in today's workplace. Accommodations for employees. I think, I don't want to say most, but probably more than 50% of employees at some time or another are going to need an accommodation.
Well, it could be as simple as you broke an arm or you broke a leg.
Yes, temporarily.
And that's going to go away, yeah. But it could hinder your ability. I mean, what if you stand all day at a cash register or something?
Here's a great example. Okay, you used the broken arm analogy. You are an executive assistant to the CEO. Oh, and you type a lot. And now you have a broken arm.
Mm-hmm.
What? Pray tell, what can be done? Well, they're not perfect, but we are in the age of technology. And there are lots of devices where you wear these lovely headphones, and you have a little microphone, and you speak into it, and the words magically appear on the computer screen. Yeah, document cleanup is necessary. It learns your voice over time, your intonation, your accent. 98% accurate, 99% accurate, some of them claim. But document cleanup. If they won't give you this piece of software, well, you probably have a good lawsuit against them.
But could that software replace you completely down the road?
That's a
whole nother case.
That's a whole nother story. All right, so we do get all sorts of these types of calls in the office. They do require Cheryl to take, initially when she takes these calls, some time with these folks. Because you have to get facts and circumstances. Because when Cheryl then comes into my office to tell me, I have a prospective client to tell you about, and she's telling me the story, she knows some of the questions I'm going to be asking her. So she knows some of the answers she needs to get. And she's going to try to get them. And, very often we get people say, why are you asking me that? Well, because the attorney's going to ask me, and he needs to know. And, then we go from there as to whether or not I end up speaking to the person, or we bring them into the office, or I'm able to tell Cheryl, explain why we don't believe we're able to assist you. So we have about a minute, I think. I could sing the national anthem. I could stand on one arm.
Or you could tell us where your office is and your number.
I was going to do that, actually. All right, my office is in Stewart. It's actually right over the Roosevelt Bridge. It's 611 Southwest Federal Highway, Suite A. And the phone number is 772-781-8003. And give us a call. Cheryl or I will be happy to talk to you or get back to you. And if you want to leave us a note about your situation, go to our website and fill out a contact form at www.stewartaddresslaw.com. Until next Friday, when hopefully we have much warmer weather, I'm Stewart Address, and this is Ask a Lawyer. Have a wonderful weekend.